Welcome to Frank Bruno Law. I'm Frank Bruno. I'm an elder law and estate planning attorney in New York. Today I'd like to speak about the interesting dynamic of inheritance and divorce law. I just posted a blog post about this and I want to give a little more context. Before I do that, if you'd like to ask me a question, if you feel that you need to ask me a question, please go to callfrankbruno.com. I'm looking forward to hearing from you and answering any questions that you may have. So the article that I wrote is really speaking to the question of is inheritance divisible in divorce, right? So in divorce law, there's the general rule of equitable distribution. Equitable implying fair. That means anything that we have should be divided equitably. And most courts very broadly define that as 50-50, right? It seems to be fair that we divide things in half. Now, equitable does not require it to be 50-50, so each side may in fact argue against 50-50 distribution. Now, inheritance is not marital property unless you do something to change it to marital property. That's a commingling the inherited property or transferring it in some way. And sometimes we can best describe these things by examples, right? Because we have the interplay of divorce law and equitable distribution compared to the laws of inheritance. So, if a person inherited $1 million and they inherited it today and put it into a joint account, but removed it tomorrow, well, it was probably an issue of convenience. It was probably stress or de-stress, right? Because they inherited this money. And at least in my example, to inherit $1 million, that person was probably, besides wealthy, they must have really loved you. So that's a momentary, or at least day thing, right? So $1 million went in. Now, if the $1 million was inherited today, deposited today into a joint account, and was not removed for a year, I don't know. That's a fact-specific question. Let me go to the opposite end. $1 million was put in the account today. 20 years from now, the couple gets divorced. Yeah, I think that's clear that ceased to be inheritance, and it became a marital asset because it was in the joint account for 20 years. So one day, probably not, or definitely not. I'll go on a limb and say that. This is not legal advice, right? This is a video. I play a lawyer in real life, but on the internet, it's just informational purposes only. So put the money in today, take it out tomorrow, fine. Put it in today, take it out 20 years from now, no. I give an arbitrary time frame of 10 years, no. Definitely marital property, right? It's my opinion. 9 years, yes. 8, 7, 6. We get all the way down. How about a year? I don't know. Again, why was the money left in there for a year? Now, I just used a sum of money, and that could have been cash or brokerage accounts. The thought process and the considerations would be the same if it was property. But in the next example, would it be an investment property? Would it be a marital residence? Could it be that you inherited a home and then the husband and wife moved into that home? Well, at what point does the inheritance stop being inheritance and change into a marital asset? Well, we have to take a look at that. If a person did inherit into a trust and then moved into that property, if it was in the trust for the duration of the marriage, it would never become marital property. Right? It's like living in your friend's house. Doesn't matter if you're there for 30 years. It never becomes yours. Right? Recently, I had to cancel a power of attorney. Right? So it's revoking a power of attorney. The circumstances were such that a power of attorney had been given to a spouse, and now the couple is in the midst of a divorce. So it's a good idea to revoke that power of attorney. And we do that by notification. It's a letter to the person. We reference the power of attorney, the date it was executed, notarized, and state, as of this date, whatever the date might be, as of Halloween 2021, I hereby give you notice that I'm revoking the power of attorney. And then we mail that to the person. Whenever someone has to use a power of attorney, they have to declare by affirmation, a sworn statement. They have to affirmatively swear that the power of attorney is in full force and effect. So if you don't physically get the power of attorney back, the agent of the power of attorney document, if they have the power of attorney, even after you revoke it, they still must affirmatively swear that it has not been revoked. Why am I saying that? Well, if they get the revocation and still have the original power of attorney, theoretically, they could use it. Right? They'd be committing fraud. They would be using it in opposition to the revocation. Right? But sometimes bad actors do bad things. But the notification date, you can send it by regular mail, certified mail, and keep a copy. And then if it's used thereafter, you have some recourse, right? You can demonstrate that on this date, I did revoke it. Sometimes in the law, that's all we could do. We take steps, we memorialize them, and then we're ready to litigate should the need arise. Almost invariably in every conversation I have with estate planning clients, they'd like to transfer their deed to a loved one, to a child, an adult child. Now, that certainly can be a strategy. However, I also get have many conversations where that has gone wrong. I posted a video about life estate gone wrong. Well, I had another one yesterday. The situation was a client came in, prospective client now. They had transferred their deed to their son, couple, and the son is now going through a divorce. So the deed was in the son's name. He lived there with his spouse, and the son is now going through a divorce, and the daughter-in-law is making a claim for that house, at least a portion of the house. We now have the conflicting laws of divorce, which is matrimonial law, and the area of equitable distribution, butting up against inheritance laws. They're very fact-specific inquiries as to whether or not the property was changed from inheritance to a part of the marital estate. And if you have any questions on this type of situation, please give me a call. Check out my website, frankbrunolaw.com. I was fielding a few questions yesterday about a situation that I described on this Facebook post. It was where parents had transferred a deed to their only son, and while he's going through a divorce now, his wife is making a claim for a portion of the home. And I indicated that was the meeting of divorce law and inheritance law. I'd like to explain a little bit further. Now, the parents are still alive, so really, when they transfer a property to their son, it's not inheritance, right? Because they're still alive. However, it's in the vein of inheritance. It's in the area. It sort of feels like it should be inheritance because it's from parents to a child. But that's a gift during their life. So it's different than inheritance. Inheritance, when you give to a child, it's never marital property. So if my parents left me $1 million and I put it in a separate bank account with my name on it only, and I leave it there untouched, that's always going to be mine, and it's never part of the marital estate. So if I ever got divorced, that $1 million would not be part of the amount to be split with my wife. And we're married 21 years. I don't plan on getting divorced anytime soon, but you never know. She can meet someone a little nicer, better looking, a little smarter, but I can only hope that that doesn't happen. But that $1 million in my example never becomes part of the marital estate. Now, the house in my scenario yesterday is a little bit different because if I was given a house by my parents, and it was a gift, and I lived there with my wife and my 3 children, sometimes people take a mortgage out on the house. My salary and income would go towards the payment of the mortgage and insurance and all of the expenses, but so would my wife's. Her salary would contribute towards that as well, right? And how do we figure out who's paying what unless we have separate bank accounts? So it becomes a murky situation. And that's why you really never want to you never want to give anyone that you love a gift unless you can really tie it into to the laws of trust, inheritance, and asset protection. There is a strategy that could be employed that you could give a gift during your life for the benefit of your child or children, but it has to be done in a certain way. So I can help you with that certain way. I was involved in a matrimonial trial. Well, almost a trial. I've been involved in a matrimonial case since December of 2019. And the litigants, the parties, weren't able to settle the case, and we were scheduled for trial today. And, full mask regalia on. The court was sparsely populated. But in the case, we had an attorney for the plaintiff, defendant, mother, father, and for the child. And the issues at bar, the things that were being discussed, negotiated, the terms that could not be resolved was custody, joint and legal, shared residential or not, child support, and some other equitable distribution issues. And the parties went all the way to a trial today. But what we did in the 11th hour, from early on this morning, we resolved the case by handwritten stipulation. 28 pages. And we addressed all those issues. Now, when you negotiate and really, so it's sort of a compromise, sort of an agreement, a negotiated settlement and resolution. When you do everything at once like that, there's ways to globally see what can be moved around. Well, if we get down to the minutia, you're going to have Easter, and I'm going to have Thanksgiving, and I'll have Christmas. And do we keep Christmas as a package, or do we give the one parent, every Christmas Eve, and the other parent Christmas Day? Do we alternate? How about New Year's Eve and New Year's Day? Is that a package? So these are all things that had previously not been able to be resolved. And Clearly, the holiday schedule was not able to be resolved in advance because both sides were seeking residential custody. But in the advancement of the case, in the betterment for all concerned, a settlement was reached today. So, I can't say a good time was had by all, but a good result was had by all. If you need to speak with me about your situation, please go to frankbrunolaw.com. Schedule an interview, read a blog post, watch a video. Any way that you can become familiar with perhaps the remedies that could address your situation. Thank you very much.